Hey everyone. So this is the first lecture video for Intro to American Law covering the topic of judicial remedies. The way this is going to work is I'm going to run through my lecture notes to you that get published alongside this video. I'm not going to talk about everything in the lecture notes. There's some stuff we're going to skip over because it's pretty straightforward. We can always go back if you have questions. You can leave them in the post test. You can, of course, send me an email in-person classes. We can spend some additional time on them in person. The purpose of this is not to be comprehensive about everything. It's to provide some additional examples, to cover some stuff that might be a little confusing, where students often make mistakes, things like that, and to cover some stuff that's just a little easier to explain verbally than it is, written down in lecture notes. So I'm going to walk through some, common areas of mistake and things like that. If you have questions after this video, right after you've gone through the lecture side by side with this, leave those in the post test, bring them to class, send me emails, all of that kind of stuff. So, first thing I want to spend a little bit of time talking about is the goal of compensatory damages. So, if you look where I talk about the difference between tort and contract cases, for example, tort cases, what we're trying to do, it's not always fully possible, but what we're trying to do is put the victim in the position they would have been in if the tort had never occurred. So let's think about a car accident, right? Sort of the classic example of a tort. If you are in a car accident, and it's of course not your fault, you might experience a bunch of losses as a result of that car accident, right? You might have to pay to repair your car. You might have to pay for medical bills, right? Well, now you're down money, right? You've spent, say, $10,000 recovering both physically, right, and in terms of your car, the property, from that injury. So the goal of the compensatory damages is to refund you that $10,000 essentially, right? So anything that you can add up, expenses that you incurred as a result of the accident, you're going to get compensated for because we're trying to almost sort of wind back the clock and put you where you would have been in if the accident hadn't occurred at all. And if the accident hadn't occurred at all, you'd have that $10,000, right? But it, of course, gets much more difficult than that the further we get from those sort of tangible expenses for which you have bills and receipts, right? So if you look at the list of compensatory damages, you'll see things like getting compensated for mental anguish, right? Or permanent disability or disfigurement. And there it's much, much more difficult to put dollar amounts on things, right? In theory, what we're trying to do is make you as well off as you would be without that kind of injury, or if you hadn't suffered that mental anguish. So in practice, what we're kind of trying to do is say, let's say you, I don't know, had to have a leg amputated or something like that. We're trying in a very abstract and hypothetical way to say, okay, well, the value of not having one of your legs for the next 50 years of your life is this amount of money, right? Now, of course, in reality, it's impossible to say what that is actually worth to a person, what level of happiness they have lost by losing part of their leg. But that's the concept, right? We cannot, at least not yet in many cases, right, regrow your leg entirely. If we could, right, the defendant would be expected to pay for that medical treatment. So, in lieu of being able to literally replace your leg, we are trying to do it in the form of money, right? Same thing with sort of mental anguish and stuff like that. There are many areas when it comes to calculating damages where the thing that we're trying to compensate you for, the restoration we're trying to make, is intangible, right? Is in a way valueless or invaluable, right? There's no way to put a dollar amount on it in a literal sense, but it's still something that we're attempting to do. So that's a tort injury, right? Contract disputes, on the other hand, are trying to do something slightly different, which is not restore you to the position you would have been in if the contract had never happened. It's trying to do in some ways the opposite and put you where you would have been if the contract had been fulfilled. And that's a really important distinction. We're going to see more of this when we talk about contracts starting next week. But as one example to think about now, let's imagine that you contract with somebody to build you a home, right? You give them a big down payment. Maybe you pay it all in full, right? And their job is to go out and build the home. They have to buy lumber and copper and steel and whatever else supplies they need to build the home. And let's say between the time you make the contract and when it was supposed to be completed, the value of copper quintuples, right? Copper is now suddenly, I don't know, let's go even further, 10 times as expensive. And now, if the contractor fulfills the contract and buys all the copper they need and builds your home, well, maybe now they actually lose money, right? Uh, Maybe they're going to come out behind and actually have to pay more than they will receive. If in that scenario they refuse to perform the contract, you sue them. If we were to take the tort approach and the court just says, well, let's wind this all back, let's put you in the position you would have been in if you've just never made the deal. Well, now you kind of lose, right? Because you made a good deal. You paid for a house at a time when supplies were cheap, the cost of supplies went up. You don't want the money back, right? You want the house. The contractor in that scenario, if we were just to rescind the contract, everybody gets a refund and we walk away, the contractor wins because they don't want to build the house. They're going to lose money if they build the house. You lose because now not only do you not have a house, sure, you've got your money back, but now it's going to cost even more to get that house. And there's been a delay. Right now, you have to go out, find another contractor, negotiate all that other stuff, pay for housing in the meantime, etc. So what the contract remedy is trying to do is say, well, hey, they signed the contract's valid. If they had gone through with it, you'd have a house. So the contractor either has to build the house or has to pay you enough money on the new market rate so that you can go out and build that house, right? Because rescinding the contract often puts one party at a significant disadvantage, a party who negotiated in good faith and made a good deal. We're not going to just rescind the contract in most contract cases. We're going to give that person enough so that they can go out and get the thing or get the service or receive the product, whatever it happens to be, that they would have under the contract. So, one thing to keep in mind, and we'll talk about this more in the contract lecture, is courts will not let you back out of a contract or just give everybody a refund because you made a bad deal, right? In the same way that if you made a good deal, you would expect that to be honored. Courts will expect you to honor deals even if you make the deal and then it turns out to be a bad one, right? If we let people rescind and walk back deals every time they made a mistake or the market changed and they lost out, well, then lots of people wouldn't make deals, right? And lots of people would get sort of screwed over because they made a good deal and then the other person just walked away. One more thing I want to talk about with these compensatory damages are future losses and future damages. So you absolutely 100% can get compensated for losses that you have not yet incurred. So some of those are pretty straightforward, and if you think about it, it should make a lot of sense, right? If I go to court and I've had an injury in a car crash case, and I my leg has been severely damaged, perhaps not amputated, but damaged, I might need years of physical therapy in order to walk normally or to adjust for it or something like that. Perhaps I've received some sort of internal injury, and now I'm going to have to get some sort of prosthetic or have some sort of medication that I'm going to need the rest of my life to function normally. You can absolutely get paid for that. It doesn't have to be the case that you go to court and it's just, what have I lost so far? It's, what's this going to cost me going into the future as well? And it's not just something like a medication that you're going to have to pay for. You can also get paid for lifetime diminished earnings, right? So if you're a lawyer, a professor, or something like that, and you suffer severe, mental injuries, right? Brain damage or something like that, that takes away your ability to be a lawyer, be a professor. Or if you imagine if you were like I don't know, construction work. You work a very physical job and you become physically impaired such that you can't work your job and can only get a lower paying job. The person that hit you is going to be responsible for paying the difference between those two things. If you're making $100,000, you get injured, it's somebody's fault, and from there on out, you're only going to be able to make 50. Well, that 50 a year is supposed to come out of their pocket. Now, we can also account, at least hypothetically, for greater career earnings as you go on, right? Raises and things you would be expected to get, cost of living adjustments, and so forth. What we can't do is award speculative damages, right? So to give you a really extreme example, you wouldn't be able to go to court and say, "Oh, well, judge, not only have I lost out on all this income, but I'm 35 years old, but I was just about to break into the NFL. I was just about to become the best quarterback in the league. I was going to get paid like $80 million. I need $80 million, right? Once we get into the land of extreme speculation and hypotheticals about what maybe you would have done, right? That's a point where the court will limit those damages and say, no, this is what you were making. This is what your sort of normal career trajectory would look like. That's what you're going to get compensated for. You can't come in and claim that you were just about to break through, right, and make a ton more money. Okay, so those are my notes on damages. Let's see what next. So now moving on to some rules about damages, right? Compensatory damages in particular. So the duty to mitigate, I want to give you an example here, right? When you suffer an injury, right, whether it's car accident, whether it's a contract breach, tort, contracts, anything doesn't matter, you have a responsibility as the victim to mitigate your damages, which means that if there are steps you can take, reasonable steps you can take to prevent your damages from expanding, from, ballooning out of control, you must do so. And if the court rules that there was a point at which you could have stopped your damages from getting worse, then anything that happened after that, right? Any point at which the damages did get worse and you could have prevented that, you will not receive compensation for. So to give you a sort of silly example, right? If somebody sets a fire in another person's store, right? You own a store, somebody comes in, tries to burn the business down, sets a fire. Well, you wouldn't have to like run back into the business that's already on fire to like, I don't know, get out your safe or something like that or save your inventory, right? If it would put you at risk. But if they set the fire and you're standing there with a fire extinguisher and the fire is still relatively small, you got to use the fire extinguisher, right? You got to try to put out the fire. What you cannot do is stand there, see the fire beginning to take hold, right? And just say, well, you know what? They lit that fire. I know they got a lot of money. I'm going to sue them. I'm going to let this whole place burn down. I'm going to collect my money from them and I'm going to retire, right? If the court rules that it was reasonable and safe for you to have been able to stop the fire, the only damages you're going to be able to collect is compensation for the damage that occurred before you could have reasonably stopped it. You can't sit there and watch the store burn down. If you're injured in a car accident and you don't go to the doctor, despite the fact that you're developing symptoms, maybe you've got an infection or something like that, they're still going to have to pay you, the defendant that is still going to have to pay you for that period of time when you couldn't have prevented it. But at a certain point, it does sort of flip over where the court says, look, you got to do something. You can't just let this balloon out of control. You could have done something by, this date. Everything before that date, that's on the defendant. They're going to pay you. Everything after that date, that's on you. You could have prevented it. And you could even potentially end up worse off by not preventing it because maybe you take mitigation steps and they're ineffective. In that case, if you can't mitigate something, you would still be entitled for compensation. But if the judge rules that maybe you could have done something, you may end up with even less than you otherwise might have, right? It has to be a reasonable, version of prevention and just not requiring you to run into a burning building or like bankrupt yourself getting the most advanced medical care or something. But you have to take reasonable steps to keep your damages from getting worse. If you don't, and the judge rules, hey, these damages over here, this percent you could have maybe prevented, you're not getting that. Other compensatory damage rule, the benefit rule. So, right, this feels a little weird. Why, how could something both injure and benefit somebody? One hypothetical, sort of silly example, just to give you the principle. It could be the case that maybe, I don't know, you have an oil company or a coal company looking for coal and oil under the ground. They find evidence that there may be some on your property, and they just don't ask you. They bulldoze things down, they tear down your fence, they rip out some trees, they start digging, they find a bunch of oil, right? Well, as the property owner, you have rights to that. And maybe that oil is very valuable, right? Maybe the cost of the damage they did was $100,000, but they found $25,000 worth of oil or coal or diamonds, doesn't matter, right? In that scenario, you as the property owner have rights to whatever they found because they found it on your property without your permission, without buying it. And so you're going to get to keep that. You can sue them for the damage they created, right? The cost of replanting trees, repairing your fence. If they demolish like a building or something, they're going to have to pay for that. But they're not going to have to pay $100,000 and let you keep the oil or coal or diamonds or whatever, right? The value of what they benefited you is going to come out of the damages. So you're still going to walk away where you would have been without the accident, right? If they caused $100,000 in damages, you're going to get $100,000 of total compensation. But that oil or coal or whatever it is they found that you then get to keep and sell is going to come out of that $100,000, right? Another example where the benefit rule might come into play a bit would be something like a surgeon who's doing an operation on you who discovers some other problem, right? So they're in there to, I don't know, remove your appendix, and while they're there, they see like a tumor that's growing and needs to come out. Technically, for them to do that, they've violated your informed consent, right? They've violated some patient doctor rules, but in so doing, they have also benefited you, right? Potentially saved you some future harm, saved you future medical expenses, and so on. So those are a couple of scenarios where the benefit rule might come into play, but there are potentially any, right? If you are a defendant in a case and you believe that your actions somehow benefited the plaintiff, no matter how you think that is, you can potentially argue that and get your damages reduced. Okay, so I think that's all I have on compensatory damages. What do I want to talk about next? Liquidated damages. So there are going to be a few times you're going to see this. In fact, there are two in this lecture, where there is a thin line in the law between something that's permitted and something that's not permitted. And it's not always going to be clear on which side we're falling, right? So, what liquidated damages are trying to do, liquidated damages are trying to say, well, in this contract, it's going to be really, really difficult to figure out exactly what we would owe each other. We would have to spend a lot of time in court arguing about it and fighting about it. And we don't want to do that, right? And we want to have an agreed upon number so everyone knows what to expect. We're going to write it into the contract. That's fine and good. You're allowed to do that. But what you can't do is write something into your contract that basically says, well, this contract's for about $1,000 of goods and services, but we really don't want you to fail to hold up your end of the contract. So if you breach, you're going to have to pay us $100,000, right? That is what's called a penalty clause. That is illegal and impermissible. And as you can imagine, right, the line between liquidated damages clauses, which are great, we can have them no problem, and penalty clauses is somewhat ambiguous, right? You're going to have to convince the court that your clause that you care about, if you're arguing a contract case, falls on whichever side of the line you would like it to fall on, right? Um, the key thing that we're looking for is what was the intent of the clause? Is the intent of the clause to make everybody's life easier, to put a number on things that's reasonable so we can all just kind of walk away more easily? Or is the clause very punitive and appears designed to just stop somebody from backing out no matter what? If it's the latter, it's going to be held to be a punishment clause, a penalty clause, and it will be invalidated. You'll be able to sue for damages normally, but you're not going to get that $100,000. You can see the three-part test that courts use, right? We're looking for each element to be fulfilled. So if you want to go to court and you want to argue, hey, this clause should be upheld, they should pay us this amount that we wrote down, you're going to have to prove all three of those things in an elements test. You're going to have to show that damages would have been difficult to compute, right? So if you're just buying and selling like a commodity, right? If you're ordering, I don't know, 100 yards of lumber or something for your construction project, it's not hard to compute, right? You can just go out and buy it somewhere else. That's the number. The parties agreed to the clause in advance, pretty typical contract type stuff, and the amount agreed upon is reasonable and not disproportionate. Where it's disproportionate, where you're saying, hey, the value of this thing is X, but we're going to write a clause for 10 or 20 or 30 times X, that's pretty disproportionate. You're not going to get that upheld. Okay, that was liquidated damages. Moving on now, I'm talking about punitive damages. So, punitive damages, just like compensatory damages, are money, right? When we talk about equitable relief, we're going to talk about some things that you can get that are not money. But compensatory damages and punitive damages are the same in the sense that they are money paid from the defendant to the plaintiff, but they are substantially different in why they are being awarded. And this is something that often trips students up because these things aren't as related as they appear. So compensatory damages are designed to compensate the victim for harm they suffered, right? The greater the harm they suffered, the greater the compensatory damages. The less harm they suffered, the less compensatory damages. It doesn't matter what the defendant did. As long as the defendant is liable, they're liable for the extent of the plaintiff's harm. Punitive damages, on the other hand, are not based on the plaintiff's harm. They are, first of all, less common. And when they are awarded, they're awarded based on the defendant's conduct, right? So compensatory damages, the question we're sort of asking ourselves is how hurt did the plaintiff get, right? How hurt was the victim? We're going to pay him for that. For punitive damages, we actually don't care at all about how hurt the plaintiff or the victim got. What we care about for punitive damages is how bad was the thing the defendant did. Now, what causes some confusion here is it feels like those two things should be related, right? It's easy to look at somebody who gets very, very hurt and think, oh my God, who could have done this to them? This is the worst thing somebody's ever done. They need to be punished. And often that may be the case, right? That defendants do something really terrible and somebody gets really hurt. But it's also possible that those things might be misaligned, right? If you're a sports fan, you've probably seen, especially if you watch American football, right? You've probably seen plays that were legal plays, but somebody got really hurt or it looked really bad at first, right? Because somebody got hit really hard. And sometimes the referees call a penalty, even though it's a legal play, just because it kind of looks really bad, right? But we all sort of understand sometimes unfortunate accidents happen, and it's not really anybody's fault. And that's the distinction we're trying to make here with compensatory versus punitive damages. It's possible that the thing the defendant did was really, really minor, right? It was maybe a little careless, but not that big a deal. And it's possible that even though it was only a little careless, the plaintiff still got really, really hurt, right? Well, that would be a case where the plaintiff would be entitled to a lot of compensatory damages, but few, if any, punitive damages, right? If the defendant was just sort of regularly negligent, they weren't doing anything that out of the ordinary, they're probably not going to get punitive damages awarded against them at all, even if the plaintiff got really, really hurt. And the opposite can also be true, right? It might be that the defendant did something really egregious, extremely dangerous that could have maybe really injured somebody or really killed somebody. Maybe it was also a crime. Maybe it was also like putting a lot of people at risk, right? Maybe it was dumping toxic waste into a river or something like that. But because of good luck as opposed to bad luck, maybe nobody really got that hurt, right? Maybe somebody suffered some mild consequences. That would be a case where we might have a lot of punitive damages, but our compensatory damages are going to be relatively low. So always keep in mind when you're thinking about the distinction between compensatory and punitive damages, it's why we are awarding them. Compensatory damages are awarded to compensate plaintiffs for the harm they suffered. The more harm, the more damages. That is independent from punitive damages, which are designed to punish and deter defendants and is based on their conduct, how egregious the thing they did was. If they did something really, really bad, really egregious, they might have to pay a lot of compensatory damages, even if nobody really got that hurt, right? So both sides of those coins really matter. Similarly, there's a third kind of damage that we talk about a little bit, which are nominal damages. So nominal damages are a little bit rare because they are sort of by definition nominal, right? They are small in amount. They might be $100 or less. And if you go to court, even small claims court, right, the filing fee alone is going to eat a big chunk of that. And if you have to pay a lawyer, you're going to come out behind if all you're after is nominal damages. But they do still come up, and you should still be aware of them. So nominal damages, the most important thing to remember is that they are awarded for symbolic reasons only. They are not awarded to compensate plaintiffs or to punish defendants. What a nominal damage award is trying to do is be symbolic of a plaintiff's victory. So you might often see these paired with an injunction, which we talk about later in the equitable relief section. Basically, it's the court saying, yeah, you won. We're going to issue an order for this person to not do this thing or do this thing, right? You're going to get the order that tells them to do what you want them to do. And we're going to throw on $50, $100, something like that, as a symbol of your victory, right? That you won your case, they're going to have to pay you for this, not because they've injured you, not because they need to be punished, but just you've won your case. Here's a little bit of symbolic money. Even if this is the thing students most commonly mistake, even if the award of damages is small, if the reason that it's given is to compensate you for an injury, those are not nominal damages, right? If you lend your friend $100 and he never pays it back and you sue him to get the $100 back, or if somebody causes you an injury and it costs you, I don't know, $20 in band-aids and gauze and medical supplies to remedy, and you get paid that $20 by the court, it doesn't matter that that's a small amount of damages. What matters is why you were given it. Those are compensation cases, right? Those are cases you're being compensated for losses you suffered. Even though the amount of compensation is small, it's not nominal, it's compensatory. So always look not just at the amount. The amount can be sort of a red flag to say, hey, I need to look at this again, but also look at why the damages are being awarded to tell punitive from compensatory from nominal. Oh, one more note on punitive damages. I should go back. So I mentioned deterring defendants both in general and specifically. So this will probably come up again when we talk about criminal law. There are two types of deterrence, right? I can issue deterrence in specific, right? So we punish this defendant so they don't do it again, right? You have to pay a bunch of extra damages. You're going to be discouraged from doing whatever you did again because you know you're going to have to pay a bunch of money. That is specific deterrence because we are punishing this defendant so they don't do it again. But we could also issue deterrence in general. We're still going to punish this defendant, but now we don't care so much about them doing it again, or in addition to caring about them doing it again, we're also punishing them to make an example of them, right? If you see a news headline that said, this company did X and got fined $20 billion, whatever the case might be, other companies are going to take note of that and say, well, we should be sure we don't do that, or at least don't get caught doing that, right? That's general deterrence. We are punishing an individual for the message it sends to society. Specific deterrence is punishing that individual to send a message to that individual. And of course, it can be both at once. Just be aware that those terms are out there and different. Okay, moving on now to the equitable relief section, talking about injunctions. I want to issue a little bit of clarification about this now. First, about permanent injunctions. So when we think about permanent injunctions, we should really actually think about them more as indefinite injunctions. So a permanent injunction comes at the end of the case. It's, for example, maybe, I don't know, you have a business that is routinely playing loud music and has bright lights on and things like that late into the night, and you sue them to get them to stop. And the court says, yes, in fact, they don't have the right to do this. They're violating your right to, your property and enjoyment of your home. So we're going to issue an injunction that tells them they're not allowed to play music and have bright lights pointed at your house after a certain time. Maybe they also have to take steps to buy soundproofing, plant trees to absorb the sound, whatever the case might be, right? That's a permanent injunction, comes at the end of the case, comes after the court has made its determination about the rights and obligations of each parties, injuries, all that kind of stuff. But when we say permanent, it doesn't mean it has to be that way literally forever, right? Injunctions can be modified when they need to be modified. You're going to have to go back to court and you're going to have to explain why the injunction should be modified, but it's not permanent in the sense that it's irrevocable. If circumstances change, if rights change and obligations change in a way that affects the rights touched by the injunction, you can go back to court and have the court change it. Courts could also, if they wanted to, like put limitations on their injunctions, have them expire, things like that. So when you see permanent injunction, still know it's at the end of the case. It's permanent in the sense that it doesn't baked into it have an expiration date or is going to get replaced by the end of the trial, but it is indefinite. It can always be changed if it needs to be changed. Okay, so contrast permanent injunctions with preliminary and temporary restraining orders, preliminary injunctions and temporary restraining orders. So preliminary injunctions are, in contrast to permanent, right, the start of the case. So We've seen a lot of this with the NCAA recently, in fact. You have the NCAA saying certain student athletes are ineligible, they cannot continue to participate. The athletes, through their lawyers, are arguing actually the NCAA doesn't have the right to do this. Well, figuring out the answer to that question, does the NCAA have the right to say this person's ineligible, they may not play college sports? That might take a while, right? Those cases might drag on for months, if not years. So the thing we're seeing coming out of these cases are often in preliminary injunctions. Temporary restraining order would be less common, but could also work. Um, Ordering the NCAA to let those students play while the case is ongoing. The purpose of a preliminary injunction and to a slightly lesser extent a temporary restraining order is to say, hey, it's going to take a while to fight this out in court. We need a ruling right now on what we're supposed to do while we wait for this court decision to be made. And what we're looking for when those injunctions get issued is the possibility that there's something time sensitive, right? So for these athletes, they want a preliminary injunction now because if what we do as the courts is we say, well, we're going to take our time, we're going to hear arguments, we're going to do some research, we're going to figure out whether the NCAA can allow you to play or disallow you to play. And while we do that, you don't get to play, right? You got to sit on the sidelines. You can't have contact with your coach. You can't be in the facilities. We're going to say until we decide otherwise, you're ineligible. Well, that might cause them permanent injury, not in the sense of physical injury, but in the sense that it might uh, end their careers entirely, right? They might age out. They might get too old to be competitive. If they're not able to access training and facilities and dietitians, they might get out of shape and not be able to compete at a high level anymore. And then the problem is, right? If at the end of that entire case, the court is to say, well, actually, the NCAA can't stop you from playing. You should have been allowed to play. Now that player has been perhaps irreparably injured, even though they should have been allowed to play in the first place. So, what these preliminary injunctions declaring them eligible are trying to do is to prevent that situation. To say, look, they have a plausible case that they should be allowed to play, that the NCAA cannot stop them. If they're stopped from playing while we wait to figure it out, they may suffer permanent irreparable injury. So, our order for while the case is ongoing is they get to play. And maybe the case comes out the other way, right? Maybe the court says, actually, you're not allowed to play. The NCAA is allowed to say you can't play. Tough luck. They may have got to play an entire season in the meantime, right? But the NCAA won't suffer a permanent injury as a result of that in the same way that they would. To give you one more non-sports example, imagine that you have some property that's in dispute between you and your neighbor, or some property that's in dispute between you and the city, or the city and a different private person, and somebody wants to make changes to that property. Your neighbor wants to tear down a bunch of trees or wants to like plow the land to plant crops or to dig up the dirt to, have a diamond mine or something. Or the city wants to tear down a potentially historic building. Well, if we just allow that to happen, right? If we allow somebody to come down and bulldoze a building while we wait through the courts to figure out did they have the right to bulldoze it, well, we can't really go back, right? The thing is lost. The thing has been damaged and destroyed and maybe can't be restored. So another injunction you might see in a case like that would be to say, hey, while this case is pending, nobody can touch this land. Nobody can tear down these trees. Nobody can not just tear down the house, but nobody's allowed to modify the house. Basically, what we're trying to do with a preliminary injunction is kind of hit pause while the court case is ongoing. And to the extent possible, we're trying to make sure that nothing irreversible can happen while the case is ongoing. Sometimes that does mean that people are stopped from doing something and then later told, actually, you do have the right to do that. So there may be some injury in the sense that, like, they were delayed from doing the thing they wanted to do, and that might cost them money and other things. But we're trying as much as possible to prevent things from getting worse, prevent irreversible actions from taking place while a court case is ongoing. Moving on, I want to talk about restitution, and I specifically want to talk about unjust enrichment and give you a sort of unusual example, but one that I think will help get it home. So, remember when we're thinking about compensatory damages, what we're trying to do is compensate plaintiffs for the harms that they suffered. But sometimes there are weird cases where just giving them what they are owed in terms of, hey, you had, $5,000 in losses, here's $5,000, doesn't quite feel right. There's something quite missing. So the example I like to use here is imagine that your roommate steals your car. And imagine that the value of your car is $5,000. They steal your car and they sell it to somebody for 5,000. Actually, let's change this example. They sell it to somebody for $10,000. Well, if they come back to you and they say, "Hey, I stole your car. I sold it for $10,000. Here's $5,000." Technically speaking, you don't have any damages, right? You don't have any damages for which you can get strict compensation. Your car cost $5,000. You have received $5,000. As far as the courts are concerned, that's the same thing, right? $5,000 worth of car in the eyes of compensatory damages is exactly the same as $5,000 worth of cash. But it feels wrong that your roommate has now profited $5,000 from not only doing something illegal, but from wronging you, right? You had this value. This was your car. One, you should get to choose. Do I want $5,000 of car? Do I want $5,000 of cash? And two, if there's extra profit there to be gained, should go to the person whose property it is, right? You own the car. If somebody's going to get $10,000 for it, that should be you. So unjust enrichment would come in this type of case to give you that remaining $5,000, right? Sort of potentially separate from punitive damages. So unjust enrichment is kind of this catch-all blanket category where we say, hey, we don't really have another type of damages or another mechanism where this particular harm fits in, but this person profited and they shouldn't profit from that. So we're going to make them give the profit to the plaintiff. Car stealing is just one example. It could potentially be anything, but it's something like that. Somebody takes advantage of you and compensating you doesn't capture all of the profit. So we're going to give you some additional money. Okay, last couple comments here. So, declaratory judgments. I told you that there were going to be a couple things in this lecture, a couple moments where we have two things, one's legal, one's illegal, and the line between them is pretty fishy. This is the second one, right? Declaratory judgments versus advisory opinions. So courts in the United States, most courts anyway, all federal courts and most state courts are prohibited from issuing rulings unless they have a case, right? There's something called the case and controversy requirement. It is in Article 3 of the US Constitution. It is also in most state constitutions. It says courts, judges, you're not here to just sit around and make pronouncements about law. That's what the legislature is for, right? The legislature is supposed to say, this is the law, we're changing the law, we're modifying it. And they don't have to be prompted to do that. They just get to make the laws, right? Judges are supposed to clarify the law and articulate legal rights when there's some sort of dispute. If there's not a dispute, judges aren't supposed to do anything. But declaratory judgments and advisory opinions are sort of where we find that line. What courts aren't supposed to do is issue advisory opinions where the legislature or a private citizen goes to them and say, hey, if I did this, would that be legal? The answer that courts are supposed to give, they just, of course, in reality, just dismiss the case. But rhetorically, what they're supposed to say is, well, I don't know, go do it. Then we'll decide, right? Or sue me when they do it to you, sue them when they do it to you, and we'll have a court case and we'll figure it out. Advisory opinions where the court just says that would be illegal, or if this happens, this is how I would rule, not supposed to happen. Declaratory judgments are the courts basically doing that in a way that is allowed to happen. We're not going to worry too much about the distinction between these two things. It is a bit of a gray line. The idea of a declaratory judgment is you have two parties that are actually kind of sort of in a dispute and unclear about their rights and obligations, and they go to the court and say, court, what are we supposed to do? Right? So one way that might happen would be maybe somebody's having a dispute with their insurance company where the insurance says, hey, this damage that was caused by a flood. We don't cover floods. That's on you. And the other person says, hey, actually, no, it wasn't the flooding. It was the wind and the rain that did it. So you do have to cover me. And they go to the court and say, Judge, what's this policy say? What's this contract say? Who has to pay for it? Right? Uh, in theory, many courts, because they don't want to run afoul of this rule, might go back and say, well, sue each other and we'll find out, right? Let's wait till somebody has damages. But when you've got a real contract and plausible disputes, you don't always need to get to the point of damages before you have the lawsuit. Another example might be whether something's constitutional or not. So Let's say you run a business and you sell loot box type stuff, right? So that might be trading card packs, that might be like collectibles like Labubus or Funko Pops or something like that that come in opaque packaging. You can't see what's inside it. When you buy the thing, you open it up, you see if you got a good one or not. And sometimes they're worth a lot of money and sometimes they're worth nothing. Lots of countries have restricted these. Don't let them be sold to children, maybe ban them entirely, right? Because they're functionally gambling. Well, maybe if you run that business and your local legislature or city council passes a law and bans them, well, if that law comes into effect, you might have to shut down, right? And if you shut down and then turn around and sue, even if you win, you've now bare minimum missed out on months of revenue. And even then, you might not be able to restart your business, right? Maybe you had to let go of the lease. Maybe you had to sell the property. Maybe you had to vacate the building. Maybe you sold off your inventory. You might have incurred a lot of losses. So, a declaratory judgment would be like you, the business owner, going to court and saying, Judge, declare this law illegal because if you don't, I'm going to suffer all these losses. And what makes it a declaratory judgment rather than just a regular case is in this hypothetical, you haven't suffered anything yet. The government hasn't actually tried to enforce the law. If the government showed up, officers from the attorney generals or whoever sent you a letter, showed up to your business and said, you're not allowed to operate anymore, boom, now you've got damages. Now you got a case in controversy because you're shut down. But suing before you're shut down is asking for a declaratory judgment. So, know that declaratory judgment is an option. It's something that can happen, is something that's useful for sorting out rights before a law has been enforced or before a real damage has been incurred. For now, we're not going to worry too much about sorting out the nitty-gritty of, well, when is it an advisory opinion? When is it a declaratory judgment? Just know that they're out there. Declaratory judgments, good and fine. Advisory opinions, not so much. But we're not going to worry about when one is one. Oh, last thing I just want to mention in the same section while we talk about active case or controversy requirements. That requirement also means that courts are not allowed to issue opinions when cases are moot. So what sometimes happens is a case will start, and by the end of the case, the dispute has already been resolved, right? So for one famous example of this, a student advocate applied for admission to, I think this one was at the University of Washington School of Law. He was denied. Student was white. Washington had an affirmative action type program at the time. Student sued and said, hey, this violates the Equal Protection Clause. I've been discriminated against on the basis of race. I should be admitted. This program should be struck down. While the case was pending, he was allowed to study, right? They admitted him. They went through the course of, his normal coursework, did all the normal law school stuff. By the time the case was set to be decided by the Supreme Court, he was just about to graduate. And both the school and he had said, look, no matter what happens in this case, I'm finishing, right? The school said, look, he's already in his last semester. Even if you tell us that we are allowed not to admit him, we're going to let him finish. Technically, then the case is moot, right? Because no matter what happens, no matter what the court rules, the outcome is going to be the same. We also see this in Supreme Court cases about, or federal court cases about abortion, right? If a woman goes to a clinic or attempts to receive an abortion and cannot, well, by the time that she gets to the Supreme Court, it's very likely going to be more than 9 months later. That pregnancy is going to have ended in one way or another. No matter what the court rules, the pregnancy either came to term or it did not. So, in cases like that, courts are supposed to dismiss the case and not make a ruling. For high level federal courts, particularly the Supreme Court, they will do two things that are slightly different. So in those types of cases, they will, one, often try to fast track them so they can make a ruling before the case is moot. And for important cases like abortion cases and these sort of affirmative action type cases, sometimes the Supreme Court in particular will waive the mootness requirement and say, well, we need to make a ruling on abortion cases in general. And if we hold really fast to the mootness rule, we're never going to get to make a ruling because the case is always going to be moot by the time it gets to us. So, general rule, if the case has sort of wound up and the outcome isn't going to depend on what the court says, it's supposed to be dismissed. for lack of case or controversy. It's supposed to be dismissed as moot. But in some cases, courts will go ahead and make a ruling anyway if it would be really impossible or really unlikely for the case to ever not be moot, right? If you require that the woman still be pregnant and still be eligible to get an abortion by the time she gets to the Supreme Court's never ever going to say anything pro or con about abortion because the case will always be moot by the time it gets there. Okay, last couple comments here. We're at the bottom of the lecture notes talking about attorney's fees, talking about collecting, especially from reluctant and impoverished defendants. So, a couple things I want to make a note of on this. First, you may have heard the old adage, you can't get blood from a stone, right? Same thing applies to judgment debtors in cases. So you go through a court case, contract, tort, doesn't matter. You win. The judge says, defendant, you're going to get paid, or defendant, you have to pay $100,000. And you walk away with your shiny piece of paper that says, I'm entitled for them to pay me $100,000. But they just say no, or they can't pay you at all. They don't have any money, right? Perhaps they're homeless. Perhaps they are living at or near the poverty line. They don't have $100,000. Lots of things you can do to try to get paid. Often trying to get paid is the hardest part of collecting on a judgment or of getting a judgment in the first place. You can put a lien on their paycheck, so you can take a portion of their paycheck before it even gets to them, or sorry, garnish their paycheck. You can put a lien on their home, so if they try to sell their home, you're going to get a piece of that, or you can prohibit them from making changes, all kinds of stuff you can do with a lien. But at the end of the day, if they don't have money to pay you, you are not getting paid. You cannot throw people in jail for being unable to pay a judgment. And you also cannot bankrupt, well, you can bankrupt actually. You cannot impoverish someone. You can't put somebody on the streets as a result of collecting your judgment. Basically, there is a minimum standard of living, right? Even somebody who owes you a ton of money, even somebody who's gotten a judgment against them, even somebody who's wronged you very heavily, is entitled to a minimum standard of living. They're entitled to pay their bills, to buy food and clothing and housing, to raise their kids and so forth, right? They're allowed to have that much money. You can only collect above and beyond those sorts of expenses. So if they make $1 a month more than the court says they need to pay for those expenses, you're getting that $1 a month. If they make less than that amount or exactly the amount the court says this is what they actually need to live, you will get nothing. When we have these types of defendants or these types of tortfeasors, people who commit torts or crimes or whatever, and then don't have enough to collect, it is said that they are judgment proof, meaning even if you get a judgment against them, there is not enough to collect. You will receive nothing. Now, of course, judgments don't immediately expire. Judgments stick around. So if they were to go and get a job and start making a bunch of money shortly thereafter, you would then be able to collect, right? But you are not allowed to like take everything from somebody so you get compensated. They're entitled to a minimum standard of living. And the last thing I'll say about collecting from defendants who aren't voluntarily paying is the discovery process. So you are allowed to not just get evidence from somebody to prove your case as you go through court, right? That's called discovery. You can ask them questions. They have to answer under oath. You can ask them for relevant documents. They must provide them. You can do the same thing when you're trying to collect. You can almost do a whole another lawsuit where you say, give us all the pieces of evidence of all of your bank accounts and stock holdings and all of your assets. And people may try to hide them, and you may have to hire attorneys and accountants to track down all of their money. But you're entitled to the power of the court to help you do that. Just like you're entitled to make them answer questions about the contract or the accident under oath, you can make them answer questions about their assets under oath. You can use the investigative techniques provided to you by the court and through your attorney to try to track down their assets, but it's not always easy. Okay, so that's a wrap on the things that I wanted to cover for judicial remedies. If you have more questions after going through this video, after going through the lecture notes, leave them in the post test, come to class with those questions, send me emails with them, and I will cover them a second time, upload additional information, do whatever I can to help clarify. Great start to the semester. This is a lot like what will look like every single week. So get used to it now, get used to the flow of things, however you like to go through them. And we'll start again next week with contracts.